state of Florida is now in session. The Honorable John N. Harris, Judge, presiding. All persons have business before this court draw near, give attention, and will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, good afternoon. All right, welcome to an oral argument session here at the 5th District Court of Appeal. As the Marshal said, my name is John Harris. I am joined on the panel today by Judges Eric Eisnagel and Adrian Soud. Two cases on our docket today, a couple of housekeeping matters. Each side has 20 minutes. Appellant, you can reserve as much of that time for rebuttal as you would like. We typically set it at default at 5 minutes. If you want anything other than 5 minutes, not a problem. Just please let us know when you come up. If you have any cell phones or other noise-making devices on, please be sure they are silenced or turned off at this point so that the proceedings are not interrupted. And just so you all know, the hearings today are being live streamed and broadcast on YouTube and available for your watching pleasure later on. So two cases again on the docket today. We are going to start with case number 22-2823, Duran versus Crab Shack. Counsel for appellant, whenever you're ready, you may proceed.
Good afternoon, may it please the court. My name is Chad Barr, and I have the pleasure of representing the appellant in this case, Jose Duran. I've appeared before each of you before, and it's a pleasure being back in person. I just want to say, this feels like home, and it's nice coming home because this is the only courthouse that has a podium that actually fits me. So it's nice to be back in person. Getting to the matter at hand, we're here today asking the court to reverse the final judgment and summary judgment in this case for two reasons. There are questions of fact as to whether or not the Crab Shack had actual notice of the dangerous condition that caused Mr. Duran to fall. And if the court does not agree with us on that point, there are a jury question as to whether Crab Shack had constructive notice of the dangerous condition that caused Mr. Duran to fall. I'd like to start with what we feel is the most obvious point. The point we started with in our brief is the issue of actual notice. The argument with respect to actual notice is that there is sufficient evidence upon which a jury could find that the Crab Shack employees actually created the dangerous condition that caused Mr. Duran to slip and fall. In Florida, business owners have an express duty to keep the premises free of foreign objects and transitory substances that might foreseeably injure someone.
What was the best testimony for your case, counsel?
Our best testimony is Ms. Ortiz's testimony.
I agree. And her testimony, at least on one point, is not entirely clear to me. When did she first see the liquid dripping from trays? She seemed, honestly, at 351 of the record, she seems to very clearly answer that question. And then at 355, she seems to equivocate. So what do we do with that?
Yeah, I think that she is testifying at one point, and I think the defense attorney tried to lock her in to the testimony saying, well, you didn't see this liquid dripping until after. And she said that...
She said, yeah, you could say that.
I'm sorry?
She said, yeah, you could say that. She agreed with him, right?
In terms of...
She didn't see any dripping until after Mr. Duran had fallen.
I don't think that's not how I interpret her testimony, because she said, the question was asked, you didn't actually see a waiter or a customer drop or spill any liquid, did you? She said, I did see the wait people, the servers coming out with trays, and they were dripping. I did see that. Appellee's counsel then asked Ms. Ortiz if she only saw the server spilling the liquid after he fell, and she responded, no. No.
That's at 351.
That's at 351. No, it was always when you saw when they were coming in and out of there, even while you were walking towards there. They were coming in and out of there all the time.
Until that point, her testimony seems pretty clear, and I interpreted it as, hey, I saw it before the fall. I saw this happening before the fall. But then at 355, it seems to become a little bit more equivocal, right? That's where she says, you could say that probably before. She even says probably before instead of, yes, I saw it happening before the fall. Help us out here.
I think this is the exact reason why summary judgment's not appropriate generally in negligence cases. What you have here is you have someone who testifies one way, and then you have attorneys who, we're very good at what we do, and we're very good at getting people to say things that we want them to say, especially when they're not trained in how to do this kind of stuff. So we've got a situation where she's saying early in the deposition, I saw them dripping the water as they were coming in and out of the door. And then it's only when defense counsel starts questioning her about what she observed after the fall. So I think in the early part of the deposition testimony, 351 of the record, she's saying, this is what I observed before the fall.
Well, can one witness create an issue?
Absolutely.
The same witness with conflicting testimony create the issue that must be resolved?
Yes.
All right, so then page 355 of the record, what my capable colleagues were asking about, specifically, it's page 51 of the deposition, line 11. All right, so you don't see the dripping off the tray until after you're sort of seated with Mr. Duran after the fall. Is that correct? Answer, well, you could say that. That's when it mattered to look at it. In other words, we have to look at the testimony of Ms. Ortiz in toto, and is not she answering a very direct question, which seems to be plainly stated, doesn't seem to be any subterfuge or anything of the sort. I know you're not suggesting that. But doesn't it seem to be perhaps she's making a deduction? Earlier in her testimony, she observed something after his fall. She's deducing it's taking place. I don't think they're seated nearby this area from the record. Is that right?
I would agree with that.
Okay, so she's seated a good distance away, and she's now in an area that's heavy traffic, but it's the only exit door for the servers from the kitchen, but patrons are walking through that area as well, are they not?
Well, there's no direct testimony of that. The testimony is that customers do use that area.
Okay.
No direct testimony that they were doing it.
So then as it pertains to the evaluation of your argument on actual, which is where you began, what are we to make of the testimony on page 51 as it pertains to what it is that she actually observed prior to his fall?
I think that all of what we're discussing right now is perfect fodder for cross-examination and argument in closing at trial. Whereas the saying, well, what is she saying? Is she saying she saw it before? Is she saying she saw it after? You can evaluate her testimony as a jury. And that's kind of what we're doing right here. We're asking.
Look, I think that's a really strong argument under the old standard, right? So, but why is that argument still how can you prevail under that on that argument under the new summary judgment standard?
Well, we just look at the cases that we cited in our brief, and I think that we've got some really good cases in there talking about. The demerit case, I think, is a really good one. That's the one with the milk dripping out of the cooler, and there's no evidence of anything. It's literally just, well, the way it's stacked, the way the milk is stacked, it could have been an employee or it could have been a customer. We don't know. It's toss up. But the court said, Judge Byron said very clearly that that's an allowable inference for the jury to say that the store created that problem because the store could have stacked it that way. I really don't think that it matters whether she saw the water being dripped before or after, because at the end of the day, what the observation was is that water was being dripped off of trays even after he fell. Mm-hmm. And we go right to this Walmart case, which Judge Byron just decided this case just in 2023, and we're talking about permissible inferences, and it's in a footnote, but it's so pertinent. And what he says is the standard for determining whether an inference is allowable is generally whether it is a reasonable one. That is, whether it is one that a reasonable and fair-minded man in the exercise of impartial judgment might draw from the evidence. So whether she saw it before or after, I really don't think is the linchpin. Water is unrefuted. That servers were coming in and out of the kitchen.
It matters for whether it's actual or constructive, though. Yes or no?
No, I don't think it matters because at the end of the day, water was being dropped in the exact spot where he fell off the trays. And she says even after he fell, they were coming in and out of the kitchen still dropping water.
So, I mean, is it your position that because the witness saw liquid coming off the trays repeatedly, right, not just one server, after the fall, that there is a permissible inference that that was happening all night?
If the,
Because look, let's be honest, right? If we knew for sure that the very first drip occurred after the fall, you lose, right? I mean, if we knew that for sure.
If they can prove,
No, if we knew that for sure.
yes,
then
if
you
it
lose,
was
right?
unrefuted at the
So-
first trip,
So
yes.
the only evidence that we have, the only clear direct, let's say for a moment, the only clear direct evidence we have is that, yes, multiple servers were dripping the liquid after the fall. You know, let's say 20 servers came flying by, dripping a bunch of liquid of various types, right? But it was after the fall that she saw it. Are you saying that there's an inference, a reasonable inference, that it was actually happening all night because she saw it happen after the fall?
Because it is a pattern of what she saw. Even if we look at her testimony and say, we're going to interpret it only that she saw it afterwards.
Right.
If we look at that and say, the pattern of them coming in and out of there and constant, she was unequivocal that it was constantly happening. The spills were happening.
Well, it's clear that they were rushing in and out that door all night.
Right.
It's also clear that she saw the actual spills after the fall. What's unclear is was she actually seeing the spills before the fall?
Correct.
Right?
Right.
Okay.
There's no other evidence of how the water could have gotten on the floor in the record whatsoever. And so,
But don't you have to present at least an inference that the liquid was there for at least for under constructive, at least long enough?
yes, and I have a whole argument about constructive, but in terms of actual, the next case that we relied on in our brief, the Stetler versus Coca-Cola case, and that's the case where there was no direct evidence. It was circumstantial evidence. The court said circumstantial evidence to prove actual notice is entirely permissible, and that's the 11th Circuit Court of Appeal.
But your argument is, I'm trying to make your argument for you so I can understand it. I want to make sure I understand it. You're saying, look, even if the only evidence we have is that she saw it right after the fall, that is enough to give us an inference that it was happening well before the fall. Is that your position?
I don't think it has to be well before the fall when we're talking about actual notice. If they created the dangerous condition, the time frame of it being on the floor is not the
Well, if
question.
it was 30 seconds before the fall, that might not be enough.
I suppose.
For actual, though, I didn't
actual.
mean to, and I'm sorry if I don't want to interrupt you, Judge Eisnagel.
I mean, how would, I mean,
If she spilled water and waited and walked, 30 seconds is a long time. I mean, you do this exercise with juries, 30 seconds is a long time. So if she walks 30 seconds down the,
does he or she have to realize they've spilled?
again, the testimony is that it was constant. So it wasn't an isolated one-time event. So,
Okay, so you're arguing there's an inference that, hey, look, because she saw it after, you know, there's an inference, a jury could conclude that it was happening all night long.
at least before he,
And therefore, everybody knew it was happening. They knew that there was liquid on the floor.
And it was a regular occurrence.
Because everybody was dropping it, right?
right, and couple that, we got to look at the cumulative effect. You just asked me what my best evidence was. The cumulative effect of everything, the condition of the floor at the time he fell, the testimony about why there were mats, why there were slip-resistant shoes, what was going on the floor in the kitchen. Cumulatively, I think that all ties into creating at least a reasonable inference that Crab Shack created the dangerous condition that
Why don't
caused
you talk
this.
about constructive?
Well, I have a question as to actual, just a minute before you turn your attention there. Actual knowledge requires knowledge of the condition that caused the fall, not the type of condition that caused the fall, but the very condition, the very water on the floor that caused this fall. You have to have actual knowledge of that water, do you not?
If we're going to tie it down to there was one drop and one puddle, yes. But that's not what the testimony was. The testimony was that the floor was wet, greasy, and there was smashed food on the floor. So clearly there was something else going on other than one drop of liquid that
Well, Ms.
caused-
Ortiz herself says it was drops. I mean, that's her testimony, right? Page 10 of her deposition, I believe, drops. Not puddles, not like the Cracker Barrel case where it's 1 feet by 2 feet. She's talking about drops.
Yes. Again, we're getting into interpreting what people mean by their words, not in the context of this did or didn't happen, but
Well,
in the
that's what we do
context
for a
of how
living,
we-
right? I mean,
not at the. I don't think we do that at the appellate level when we're talking about summary judgment and negligence case. I don't think that's the appropriate analysis. We're talking about.
Well, I have to read her words.
I understand that, but what I'm saying is that if we're questioning about what did she mean when she said this, then that's why summary judgment is not appropriate in negligence cases. That's
She was talking about drops from the trays, right?
my interpretation of her testimony is that she saw liquid dropping off of the trays.
Right.
And liquid
She
dropping off
wasn't
the trays.
saying there was only a drop of water on the floor. She was saying
I would agree with
that she saw multiple trays come through dropping liquid on the floor from the trays.
Correct.
Well, then specifically, page 10 of her deposition, which is page 345 of the record. Question, when he was on the ground there, were there any mats or anything on the ground? Answer, no. Okay, there was question, what's that? Answer, there was like drops of water like food, okay? Like French fries. So she's talking about what's on the ground. She's not talking about trays. There's French fries somewhere on the ground, and then there's drops of water on the ground.
Also, could you address the constructive for me?
Yes.
Yeah, but I mean,
My only response to that was just simply this. We can look at Mr. Duran's testimony. He landed, his hands were wet, and his pants were wet. That belies any interpretation of her testimony as being a drop on the floor. With respect to the constructive issue, there's two ways that we feel that we have established that there's a jury question with respect to constructive. One, the condition of the floor at the time he fell, and the presence of employees in the area where Mr. Duran fell. And I'm quickly running out of time, but we've got some really great cases as well on that. The Cologne versus Outback, the Norman case, all talk about the condition of the floor. That's the plus evidence that you need. It's unrefuted that the servers were spilling drinks. Unrefuted the floor was wet, greasy, and dirty at the time he fell. It's unrefuted that there was smashed food on the floor. It's unrefuted that the liquid was brownish, and albeit refuted.
How long was it on the floor? How long was this puddle on the floor?
Well, the floor wasn't cleaned in enough time for there to be smashed food, dirt, and grease on the floor. So cumulatively, I think that's the argument. I don't think there's rarely going to be a negligence case where you can prove this drop hit the floor at this time and it was there for this number of minutes. It's impossible. But if we look at the cases that we relied on, and
Well, what is your plus here? You confused me there. What is your
yeah,
plus?
the plus is the cumulative condition of the floor. So you've got liquid on the floor, some of it brownish. You've got grease on the
That
floor.
doesn't-
You've got smashed
You
food.
don't know why it's brown, right? It could be
I
coffee.
don't know why it's brown. I don't know why the food is smashed. I don't know why.
Sometimes you could, the color of the liquid is determinative that it's been there a while, it's dirty, right?
If
You
we
don't know
knew
that
the
here.
answers to why things were on the floor, we wouldn't be here. But we don't know. We don't know how long they were there. But they were there long enough for the floor not to have been cleaned by virtue of the fact that there was smashed food on the floor, that there was grease on the floor, and the floor was dirty. And so we're just arguing there's an inference. We're not arguing the case. We're not arguing that we win. We're just arguing there's a reasonable inference that, based on those things, that they should have known that the floor was dirty enough that it should have been cleaned. And then we have I got 3 minutes left. We've detailed all this stuff in the briefs. I'll be prepared to answer any additional questions you have my rebuttal time.
All right, thank you, Mr. Barr. You got 3.5 minutes to go. All right, counsel, you may proceed.
Thank you, and good afternoon. May it please the court, my name is Elizabeth Hitt, and along with my partner, Robert Ader, we represent the Crab Shack. And I have not had the pleasure of appearing in front of you before. So I think your honors went directly to the point, too. If the best evidence at all is Ms. Ortiz's testimony, it's clear when you read it in toto that she only saw drops dripping off trays when she was right there after Mr. Duran fell.
Counsel, I don't think that's clear at all, but that's my opinion.
Well-
When I read it, it's not clear to me.
Well, and I understand why you say that.
But maybe that's good for you, the fact that it's not clear, right? Maybe you don't have to argue that it is clear. I don't know.
And I don't believe that I do have to argue, but I will anyway, only to the extent that the facts as they play out, as you read the entire deposition, Ms. Ortiz says she comes in and goes to her seat, not using that same pathway, even though Mr. Duran says they did use that same pathway. Anyway, she says she's not able to see the servers as they're coming out of the kitchen and drops dripping off the tray. It's just implausible. You can't see that. And they did sit quite a far way away from that door.
Let's say for a moment
coming out.
that her testimony was unequivocally and clearly that she saw servers rushing in and out of the door in that area from the moment they walked in the restaurant until they were walking out, and that from the moment they walked in, she noticed servers sort of routinely spilling a little bit of liquid every time they came through. Is that a summary judgment case then?
Assuming that there is testimony, which there is not, that says, I was there and I saw it dripping prior
Right. In my
to-"
hypothetical,
In your hypothetical, that would certainly be more facts, and that would be a little bit more plausible.
tell me how
that-
you get around it.
that, well, again, that's an inference that he slipped in those particular drops that they were dripping there in your hypothetical, right?
Okay.
Because we still don't know exactly what he slipped in. All we know is what Ms. Ortiz testified to that she saw after the fact, which was, as you pointed out, those little drops on the floor.
Okay. No, I didn't point that. I didn't point that out. I think that might have been someone else. But
I'm sorry.
So your position is that, based on the summary judgment evidence, that there was not a puddle on the floor, that there was at most a few drops on the floor.
Correct.
Okay.
Not a puddle on the floor.
Okay.
And I think that's where the cases can be distinguished too, including the case that was just filed last night. And that was the Del Caprio case, I believe, out of the fourth, a very recently decided one, and where they were dealing with a puddle of water, and in the case it said, quote, not drops. There were shopping cart track marks going through the puddle. There were footprints. There was somebody stationed there, so there's plenty of evidence. In this particular case, I do want to make a big point, if I haven't made it clear in the briefs already. There were no footprints in our case, no track marks, no drying of any type of a liquid, no change of consistency, absolutely nothing. There is nothing to show how long that substance had been on the floor. And there's absolutely nothing, like the trial court pointed out, to show that Crab Shack knew or even should have known that the substance was on the floor prior to the fall.
And maybe I'm just not able to recall it, the French fry that was smashed. The record doesn't seem to make it obvious where is the French fry in relation to the drops of water.
Correct. They say in the area. The area could be anywhere. The area where he fell was about 12 feet from the kitchen door. And it is an area that, and there is testimony, by the way, in the record that that is the exact area where all customers used to walk through and go to the dining room and walk back out. So there is testimony that says that rather clearly. But, and I'm sorry, I just kind of lost track of
No, the
your
French
question. I
fry, it's not in the water, it's not in puddles of water.
Correct.
The plaintiff indicated he did not slip on a French fry, it was a liquid.
Exactly.
Right?
It was a liquid, and in terms of brownish, first of all, yes, if there was a color brown, we would need a +1 to say, well, was the substance clear in its original form, and therefore it got brownish through whatever means. But there's not adequate testimony that the liquid was brownish. Mr. Duran stated that Ms. Ortiz told him that what she saw was brownish. In Ms. Ortiz's testimony, she says, I don't know. No, I don't know that it's brownish. It was, I have no idea. So there's nothing in the record, there's no competent record evidence that shows that the substance was brown. The only thing that we know is that it's clear. Mr. Duran said he didn't see it when he was walking through there. I mean,
Was his testimony that it was clear and greasy?
He was pretty unequivocal about that too. I mean, equivocal. He stated several times that it was water. He stated to the doctor that it's water. When questioned, he says, well, I'm not an expert. It could be some grease in there too. If there was any grease in there, quite frankly, I think he would have to prove both. He would have to prove that there was a liquid substance that was on the floor for a long enough duration that we would have notice of it, and there was grease on the floor for a long enough duration that we would have notice of it. Now, nobody else slipped in anything. He was the only person that went down. He stated while he was on the ground, he saw a server coming out of the kitchen door, and she kind of, slipped, didn't go down, but kind of slipped. But there was nothing before that. If that substance had been on the ground, whether it was water, whether it was
This
oil,
sounds like a good argument to the jury, counsel.
and that
We're
is
not a jury, are we?
No, Your Honor, we're not in a jury. But I'm just pointing out how the facts would play
Where
out.
in the record can I find where you're reading the substance on the floor as being just essentially a few drops as opposed to something more substantial, even a small, I mean, puddles can be very small or very large, right? But I think there's a difference between a small puddle and a few drops. Can you just point me to?
Well, in Jesse Ortiz's testimony, record at 345, page 10, and she stated, and I think somebody just brought this up, that on line 12, page 10, there was like drops of water. And I don't have the testimony ahead of me or in front of me, but Mr. Duran did state that he doesn't know how big it was. So he doesn't know the size of the droplets in this case. So we're not dealing with a puddle like we were dealing with in Thoma. We're not dealing with a puddle like we were dealing with in Del Caprio.
So it's your position, we don't know how much liquid was on the floor. It could have been just a few drops, and it could have been a small puddle. We just don't know.
The only testimony that we have is from Ms. Ortiz, and she said drops.
If there's constructive knowledge of even drops, however, then that may be sufficient to defeat summary judgment.
I would have to agree with that. If there were constructive knowledge, if somebody knew about those drops,
Or should have known.
or should have known, if that's what he fell in, were the drops, and somebody knew or should have known, then yes, I agree.
So then now we're back to the what does seem to be the closer question of, is there an inference, a permissible inference, not a right?
Right, correct.
Permissible inference.
Permissible
Even if you don't think it's a very strong one or a very good one, even if you don't think the jury will believe it, right?
Well, I think the inference has to be based upon fact. It cannot be
And
based
the fact
on...
is, she said, look, I definitely saw multiple servers dropping liquid off their tray in this area after the fall.
After the fall.
So you're going to say there's not an inference, I assume, but why not? Why isn't there a permissible inference in this setting?
Right, because it is mere speculation. First of all, she is opining, it's her opinion, it's speculation that the reason why Mr. Duran fell was because of droplets on the floor. And she's assuming that those droplets must have happened before that. It is nothing more
Let's
than
start with
supposition.
that. Let's start with the timing first. So why isn't there an inference at least that, hey, the fall happens, oh my gosh, I look up, 10 servers walk by in a span of 15 seconds, and every single one of them drops an ounce of water or liquid on the floor. Why isn't there a permissible inference that that's been happening all night?
So, well, here's a difference, if I may. So she would have to assume, and asks the jury, the judge, everybody to assume that just because those particular servers were coming out and the drinks were spilling onto their trays, which was dripping drops onto the floor, then every server coming out must have been doing that, and they must have been doing it all night long.
No,
So
that's the question. Is it an assumption, speculation, or is it a permissible inference? That's the question.
I don't think it's permissible at all. I think it's absolutely
Why
speculative.
not?
I think it's an
Well,
absolute
how is
assumption.
it? Well, what if they had hired a private investigator, and let's say the restaurant's busy Thursday, Friday, Saturday night, every Thursday, and for 6 months the private investigator goes and just watches every Thursday, Friday, Saturday night during the busiest time. And then this investigator testifies every single night without fail. Throughout the entire night, the servers were dropping liquid on the floor as they went in and out. Now, it's after the fall. At what point do we get a permissible inference that this is par for the course?
I think that's a great question. I do, in all honesty.
Asked
Right, but I don't think that that's permissible.
So never. So 6 months, somebody come in and say, I went personally watched for 6 months, and never one night, never one time was it not routinely happening. The entire night. That's not enough.
I don't believe that's enough. I truly don't. And if I can kind of make an argument here, what you're asking more like, it would be as if they had an air conditioner vent dripping. And it's dripping, and it's dripping, and it's something that has been dripping and nonstop. It's not something, based on what a human does or does not do, it's just doing that. If you had a cooler that is leaking as an employer, right?
Now, the cooler could at some point starts leaking.
It starts
It's a machine. At some point it's not leaking.
Okay.
And then the next moment it is leaking.
Right.
Right?
So if it continues to leak, we've had problems with that cooler before, we've had it fixed, they didn't fix it, whatever it may be, but it's
But
creating
if the
that
nature
condition.
of serving tables in a very busy restaurant is that we're in a big rush and gee, you know, these drinks, a little bit spills out and comes off the tray, and that just happens on a regular basis. If that's the case, why can't a jury say, well, gee, if it happened for 6 months after, then it might have probably actually maybe did happen that night?
Because the testimony from the restaurant managers say that spills there rarely happen. That's the testimony. That's the facts that we have.
Isn't that just a disagreement in the evidence? I mean, isn't that a dispute?
I don't think it's a disagreement in the evidence at all. I think it's hardcore evidence. Spills rarely happen here. This is not an area of big spills. Again, if in your hypothetical, it had occurred every day, routinely, every single night, and the PI was
Right.
watching it, then maybe it would be a different thing. But the facts that we have, the undisputed facts, is that it does not happen. There was somewhere in the briefs it was stated that there were 5 prior incidents. There were no such thing. The question was directed to the manager, and she said less than 10, yeah, less than 10. Less than 5, less than 5. Less than 5 could mean 1. So there's not any testimony that there were 5 prior incidents. Just like there's not any testimony that the mats in the kitchen don't exist. The testimony shows that the mats in the kitchen did exist. They were there. So, besides Ms. Ortiz's testimony, Mr. Duran himself decides that it must have come when servers were walking from the kitchen out to the dining area.
Yeah, no, let's
and
focus
tracking
on the
shoes.
trays and the
Okay.
liquid, right?
Yeah, and I would agree. I think
So,
that's
but just so I'm clear, your position is that no matter how much eyewitness, direct evidence, clear evidence there is of liquid falling off routinely, falling off of trays as a matter of course, no matter how much of that, if it's after the fall, it means nothing. Is that your position?
If it's after the fall, it means nothing.
Okay. So the jury would have to say, well, because we don't have any testimony from before the fall, we have to assume that all the servers just started doing it 10 seconds after the fall, and then it continued doing it for a perpetuity, but they didn't do it before.
They would have to assume, and that's the whole point, they would have to assume that it was going on prior to that.
Well, I mean, I think Judge Eisnagel's hypothetical probably is relevant as to whether or not this is occurring with regularity. I mean, constructive knowledge comes either by regular occurrence or by it existed for a sufficient time you should have known. So I think the hypothetical he's asking you is certainly a reasonable inquiry as to, it doesn't lead to just an assumption, but if it's happening chronically and repeatedly, then can we then infer that it happens?
Right.
My question is, are we then, and I understand the hypothetical is not the facts before us, are we then being invited by appellant's argument to then stack inferences? Well, A, it occurred before. We infer by the evidence that it occurred before.
Correct.
And B, that is what he slipped on.
Correct.
Is there a stacking of inferences that creates a problem?
There is a stacking of inferences, like we stated in our brief.
Well, in
And it's
fairness to
improper.
my question was just on the first, right? So if your response is, no, there is potentially an inference there, but then you would have to stack another inference. Now, that's a different question, right?
Right, but the inference.
So-
I'm sorry, go ahead.
But you don't even concede there could be the first inference.
I don't think there's a permissible inference.
Right.
The first inference, in my mind, is that he slipped in droplets of water that came from the tray. That's the first inference, right?
No, my first inference was how long has the water been dripping from the trays? That was my question. That's the first one.
That it
But you
occurred
don't
prior to.
agree that there could be a reasonable inference?
I don't agree that
That
there
the
could be.
trays were dripping water before the fall?
Your Honor, I don't agree that it would be a permissible inference.
So let's walk through then for a moment. Let's say the panel disagrees with you and says, gee, there's a reasonable inference that could be drawn from that. Now we have what you've pointed out previously and what Judge Sal just pointed out, which is the second part of the analysis, right? So then we have sort of, is that actually the same substance that caused the fall?
Correct. It could be a totally different substance. And just to let you know, too, that was never argued at the trial court, that second prong of the constructive notice. It was always argued that there was sufficient time, that the substance was on the floor for a sufficient amount of time.
Oh, the motion
That's
for,
what they
you're
argued.
saying the motion for, the argument on constructive notice wasn't preserved, is what you're saying?
That, on that second prong, correct. And I think there's a footnote in there, too, that says they
So
never
on
argued it.
on this second, this causation issue, that's interesting, right? Because if it were just a few drops, then I think that your argument has some force to it. If it was a conglomeration of drops that came together as a liquid, I'm not a scientist, but I have a basic understanding of liquids, right? Once they come together, they tend to sort of blend, most of them, right? So if it were just a few separate drops, now that's one thing. If there were enough drops over the course of the night to form any sort of puddle at all, well, now you can't possibly separate them anyway, right? So where do we go with there? So let's say that 90% of the drops were contributed by the servers. But there were maybe theoretically, do they have to prove that 100% of the drops, if it's a puddle, that 100% of the drops making up that puddle were put there by trays?
I'm not quite sure that I
Do
follow
you understand what I
but
mean? The difference between a few drops and then a puddle.
I understand the difference,
Right.
sure.
So once it becomes a puddle, my point is it's difficult to separate, which drops form the puddle and how many of it came from a server versus potentially a customer, right? Do they have to prove that 100% of that puddle was dropped off of trays from servers?
I don't think they would have to prove that 100% of it came from servers, but I think they would have to prove that there's a puddle.
Okay.
And
if
there's
they,
no puddle.
If they prove that there was a puddle, then how much of it would they have to show? I mean, would they have to show that some percentage, or would they just have to show that part of that puddle was created by servers walking through and dropping liquid?
Well, I think if you're talking about constructive notice, I think whether part or all of the puddle came from the servers or part or all of the puddle came from customers traversing the area, either way, there's a puddle.
Mm-hmm.
And that's something that they could make an argument to say, you know what, there's a puddle, you should have seen a puddle, right? But there is no puddle.
And maybe you should have known if your employees were the ones creating the puddle.
If they knew about it, if the employees knew about it.
Well,
Right?
Well, if the employees are creating it,
Yeah.
the knowledge is,
Isn't it constructive at least if
It's-
they're creating it?
There's a difference, and there's case law that says there's a difference in you create the condition and you have knowledge that you created the condition.
Well, the time element is relevant here. I'm still going on the potential, like if we have an inference that this has been happening all night. Remember I said, hey, in our hypothetical, let's say the panel decides that that's a permissible inference. Then we go to the second issue of what was the substance actually slipped on, right? Which substance was it, right?
I'm assuming, again, I'm sorry, I'm having a little bit of a hard time following, but I think I know what you're saying. So if the panel is going to decide that you can infer,
Right.
by virtue of the fact
That
that
the
it was
dripping's been happening all
after,
night.
that it was happening
Now we
before.
have to decide, was there evidence that the drops dropped by the waiters, servers, were what caused the fall? That
Right,
was
you
your
have to-
argument, by the way,
Right.
right?
Yes, I'm with you.
Okay.
So, I'm sorry, I guess I'm just not following. I guess what I'm saying is you would still, even if the water came from the server's tray, you would still have
All
to...
night long?
All night, that you would still have to show that they knew about it.
All night long? All night long. There's no constructive knowledge then? It's been
Yeah.
happening all night long?
If droplets fall off a tray and the server has no clue that that's happening...
That sounds like actual, though.
But even, remember, even with actual notice, right, even if you create the condition, you still have to show that the server knew about it.
That's actual.
Or
I'm
that-
talking about constructive.
Okay.
Constructive, the timing matters, right?
The timing, how long
If it's
it's
been
been on the
happening
floor.
all night long, and the
Right?
servers have been creating the problem all night long, right? That infers, there's certainly, a jury could conclude, if it's been happening all night long, there's plenty of time to discover it and clean it up, right?
Right, if it was actually there. And once again, I'd go back to if it's a puddle, if it's a whole lot of water,
That's different than a couple
then
drops.
it's different.
Yeah,
Then
yeah.
it's very different than a couple of drops. If it had been happening all night long too, it would be more than a couple of drops. It would be all over the place. Like you said, they would probably form a puddle altogether, but it didn't. There was no puddle.
All right, thank you, Ms. Hitt. We've let you go well over your time. Thank you very much
Thank
for your
you.
argument. Mr. Barr, we'll give you about an extra minute and a half, so take about 5 minutes for rebuttal if you need it.
I don't know if I want it. No, I'm just joking.
Counsel, does the record demonstrate that there was a puddle, or is it unclear?
I'm glad you asked. So this is what the record demonstrates, that the manager that was on site on the night he fell, he said the mat was wet. He said there was a mat and the mat was wet, so he removed the mat. Ms. Tavares testified that after Mr. Duran fell, the manager directed the employees to mop the area up, and a wet floor sign was put out.
Right.
That was actually, the manager said that a wet floor sign was put out. We have the testimony that another server slipped, trying to help Mr. Duran up. They didn't slip coming out of the kitchen, slipped trying to help him up. We've got the wet pants, wet hands. That would lead a reasonable person to believe that it's more than just drops. Look at the pants. So we got all that. Clearly, it's more than just drops. I want to go back to this. Really bothered me because I wanted to make sure I wasn't misinterpreting the testimony, but with the court's permission, I'd like to just read in part of her testimony, Ms. Ortiz's testimony. It's on page 351 of the record where we kind of started. But I want to just read this together, okay? Page 36 of that transcript on that page. I apologize that it's a condensed transcript. So you believe that, period. You didn't actually see a waiter or customer drop or spill any liquid, did you? Answer, I did see the wait, the people, the servers coming out with the trays, and there was dripping. I did see that. Question, that was after Mr. Duran fell. Answer, no. It was always when you saw they were coming in and out of there, even while you were walking towards there. They were coming in and out of it all the time, even when you were walking towards there. She's talking about when she was walking out of the restaurant.
I mean, the
before-
problem there is,
Can I want to
Yeah,
answer
go
your
ahead,
question,
go
but I just
ahead.
want to read the rest of it. The question was then, so, were you watching the waiters and waitresses during your meal? Answer, you could see them while you were waiting for the table, yeah. You could see them, and then when we were leaving, I saw them, yes. I did see them, and I saw them during when he fell. They kept coming in and out because they were working. She's, in my opinion, making it clear that she saw this happening before they were seated, when they were leaving, and after he fell. And if we get any deeper into trying to decipher what she meant by, did she see it before? Because I think there's clearly an inference, if we want to talk about inferences, that she saw this happening before. There's clearly an inference that there's more than just drops on the floor based on everything that we talked about before. And I know I think you had a question. I wanted to answer it if you.
yeah, the problem is that, counsel didn't then clarify, say, well, when did you first see it, right, to make it very clear. But, after reading page 355 of the record, and then reading that in context with 351, and at 351, she might have just been emphasizing that, man, those waiters, those servers were going in and out constantly. There was a constant flow of traffic of servers at this spot from the moment we walked in till while we were seated, I could see them. She very notably could have said, and they were dripping the whole time. The problem is she didn't say that. And counsel could have asked her to clarify it at the end, but didn't. So,
I just can't imagine that our summary judgment rules, especially in the context of negligence cases. The Supreme Court said the purpose of summary judgment is to isolate and to dispose of factually unsupported claims or defenses. And what we're doing is we've just gone through a very intriguing exercise of trying to decipher what a witness meant based on her testimony, not what was clear based on her testimony. So this is clearly a jury question as to whether or not they created it. The jury is free to look at her testimony on the stand based on direct, cross-examination, redirect, and determine what exactly it is that she is saying, and then they make the decision. If they want to move for a directed verdict based on her clear testimony, then they have the right to do that. But when we're looking at it in this context, after the fact as an appellate practice, it's not clear that she was saying, I only saw it after the fact. And
I mean, on a directed verdict, though, I mean, if to whatever extent a party has the burden, right? If the evidence is unclear, doesn't that kind of work against them?
no, I mean, if it's not clear, then you're not entitled to a directed verdict. If a reasonable jury could find, if a reasonable jury can look at this and go, I think she's saying that she saw it before, then it's not clear and unequivocal. It doesn't. You have to take these facts in the light.
But we have to read the entire well, maybe we don't. I mean, don't we have to read 351 and 355 and say, look at both of them and say, what do these mean together?
I think you have to read them and say, I have to interpret this in the light most favorable to the non-moving party. I think that's what summary judgment rules require. I'm out of time. Thank you for your time today. We're asking the court to reverse and remand for a trial. Thank you.
All right, thank you.
Thank you very
both
much.
very much. Well argued and well briefed case.